The Cannabis for Private Purposes Bill, which has been out since 2018, has finally been adopted by the National Assembly. This follows the groundbreaking Prince judgment of the Constitutional Court. But what are the parameters of this piece of legislation, and what do you need to know about how to legally use it? Ras Gareth Prince, a Rastafari Lawyer and chair of the Cannabis Development Council of South Africa and champion of these developments, joins us now. Good evening to you, and thank you very much for your time. One only imagines what your reaction was after this passed, after waiting for 5 years.
Good evening, and very warm welcome to all of the viewers. We were not pleased. After 5 years, we really expected that our government was going to meet us halfway and that they would use this opportunity to develop a legislative blueprint that could have been the envy of the rest of the world, but unfortunately fell way short of what was expected by the South African cannabis community, as well as falling short of the constitutional requirements set by our law, our constitution, as well as past court judgment. As just to make one example, the National Assembly just passed a bill that does not make provision for where people can legally source cannabis. So as it stands, we've got a right that exists in theory, but which cannot be manifested in practice unless you break the law. And that is unacceptable anywhere in any democratic society governed by a constitutional democracy standard.
Well, let's talk then. I mean, you raise one anomaly or one shortcoming of this, and if there's time, hopefully we can get into some more. But about those parameters, remind our viewers where it is legal to grow and use then.
Well, so in terms of the 2018 judgment, adults were granted the right to cultivate cannabis, to use cannabis, and to possess cannabis in their cars, in their houses, and that would not be against the law. However, the Constitutional Court did not confirm the provisions that said that the dealing in cannabis provisions in the law was unconstitutional. So if people cannot legally buy cannabis or seeds or clones, then they are not in a position to exercise their rights. And technically speaking, they would then have to break the law in order to exercise their right. So it was the duty of Parliament to ensure that there is a legal source of cannabis, which there is not. And this bill does not speak to that at all. Neither does it speak to the commercialization of cannabis, because one of the purposes of the bill, which you read in the preamble, is to prohibit dealing in cannabis. Now, that in itself, it contradicts the fact that there's a cannabis master plan in which commercialization of the plant is at the center, because cannabis has been recognized as one of the 7 key priority areas for economic development.
Yeah, Ras Prince, this is so interesting because I think you've just so simply and eloquently pointed out the conundrum. It's almost as if, you've been given something with the one hand and it's been taken away with the other hand. So what can you do about it?
So as it stands, the National Assembly assented to this bill. So the law requires that it now be sent to the National Council of Provinces. But there we find ourselves in another conundrum, because by virtue of the manner in which this bill was brought to Parliament, technically speaking, it means that even if the NCOP says that we do not agree at all with the direction that this bill is taking, and we direct that it takes this course, the National Assembly is not obliged to take that into consideration. And they may then, when the bill is passed back to them, simply pass this bill by a simple majority. Whereas the cannabis community have said that this bill should have been brought to Parliament as a Section 76 bill, meaning that this is a bill that impacts on the competencies of provinces, and therefore there is a concurrent competency between national executive powers as well as the provincial legislative powers. And the fact that this bill was incorrectly tagged is something that renders the whole bill unconstitutional. Now, we definitely do not want to go back to court to complain about the constitutionality of the bill, because it is Parliament's duty to ensure that the bill that they present to the South African community complies with all of the constitutional provisions contained within our constitution, and not just the one on privacy. Therefore, the fact that this bill is called the Cannabis for Private Purposes Bill is, as a matter of fact, a contradiction in terms, because laws in South Africa are supposed to be interdependent, interconnected, and interrelated. And this bill is disjointed and disconnected.
All right, so it sounds like a dud then. I mean, we'll go to one of the things that it provides for in terms of criminal records and so on, if there's time. Are you suggesting then, in order to have the bill which adequately, meets the threshold of application, usability, it does what it's intended to do, it suggests that you might have to start this all over again. And given that you've been to the Constitutional Court to even begin the process, early on, then it's been, then it became, it was a piece of legislation and a bill, and now it's been waiting for so long, finally adopted, but it doesn't pass muster. What options do you have now?
Our final hope now lies with our president, the Honorable Cyril Ramaphosa, because he has got the prerogative to refer this bill to the Constitutional Court to test as to whether it complies with our constitutional standards. But we have pointed out to the National Assembly more than 2 years ago that, as a matter of fact, that the manner in which they started off with this bill, our constitutional democracy dictates that the National Assembly cannot develop any laws without the consultation of the communities of interest. And the National Assembly did not arrange any public hearings, right? It is the prerogative of the NCOP to do that, but it should have been done by the National Assembly. They were the ones that were supposed to have educated, informed, and involved the community when they were drafting and conceptualizing this bill, but this didn't happen. So the fact that it was brought to Parliament in an incorrect manner and tagged incorrectly, as well as the failure to facilitate adequate and meaningful public consultation, those are things that in and of itself renders the bill unconstitutional. And even if we go back to the Constitutional Court, the court will only order us to go back to Parliament and work this out with Parliament, because it is not the court's duty to construct laws. It is the duty of Parliament. And Parliament is made up of the National Assembly as well as the NCOP. So this bill, it would seem that we would have to start afresh, because we've got to do it right from the outset. And it is the people of South Africa that is suffering. If I can just make one example, Colorado, for instance, they started also in 2018. And by now they have already raised a couple of $2 billion in taxes. But we have put another 1 million people in jail since 2018, which makes absolutely no sense. Instead of putting people to jail, we should put people to work.
We're going to have to come back to this one. It is, as you say, not at the end of the road, completely undesirable as this bill stands in its current form. Ras Gareth Prince, Rastafarian lawyer and chair of the Cannabis Development Council of South Africa.